with Appellate. There were times in the record that there was lack of prosecution. The case was almost dismissed.
Yes, Your Honor, and thank you. I want to clarify that statement, meaning that the court did not afford Ms. Lavender due process at this particular hearing because no pleadings, motions, or notices contemplated the actual termination of her alimony, and that wasn't what was noticed for hearing. The only two things that were noticed for hearing were Ms. Lavender's motion for enforcement. Well, it's titled a motion for contempt, but if you look at the wherefore clause, it's clearly just seeking enforcement remedies, and likewise with the accounting arrearages. I don't know, Your Honor. We didn't get involved in this case until the appellate level. I don't know why this case was not called up for an enforcement evidentiary hearing well before now.
Right, and look, the operative pleadings that I see, and I want to defer to my colleagues who I know have questions as well, but the second amended petition to establish the decree as a Florida order was April of 2014. The next operative pleading is a second supplemental petition for modification of alimony in November of 2016. We are 8 years from the last pleading, and there's no indication that, at least I saw in this record, that any of the 5 prior counsel tried to bring those issues before the court.
Yes, Your Honor. And first of all, I want to clarify something that, again, these petitions that are in the record that are titled modifications is filed by Ms. Lavender. If the court looks at the substance of them, it's, again, just seeking enforcement and whatnot. And I agree with the court. These should have been set for hearing and called up for hearing. It is our intention, if the court grants the relief that we request and sends the case back to the trial court, it's our intention to continue to represent Ms. Lavender and to call this up for hearing for enforcement purposes and conduct that evidentiary hearing post haste.
Well, in the same vein with due process, when the motion that we're here on, at that motion hearing, it's my understanding your client wasn't there, and there was some discussion about outstanding discovery for a year and a half, and the judge said, you know, we're talking about Social Security and the numbers, and so we can do the math. It's your client's burden, having brought the motion, and there's no evidence. She's not there. And then they ask, why hasn't discovery been answered? And counsel said, well, my client won't return my phone call, so can't really give you an answer. So why are we having an argument here that there's a lack of due process?
So, yes, Your Honor, and thank you. The issue with the discovery, I will point out that Mr. Bryson in that time had never filed a motion to compel or never sought to pursue that discovery. That issue was raised at that hearing. It also was not noticed at that hearing, a lack of discovery. And I would point out in the transcript that Mr. Bryson was not present at the hearing either. It was a Zoom hearing. I don't believe that either counsel were treating it, and I'm saying I don't believe, I don't know this for sure, but I don't believe that either counsel were treating it as an evidentiary hearing.
Well, if you say remand for this to be reconsidered, what's to be reconsidered? The math is the math.
Well, yes.
What else needs to be fleshed out here?
So, Your Honor, evidence actually needs to be put on as to what Social Security benefit that Ms. Lavender is receiving under Mr. Bryson's credit. If the court, and this is where we believe that the trial court misapplied Frazier v. Frazier. If you look at the transcript and the order, it just says that the judge believes, or, you know, and I forget the exact terminology, but the court relied upon argument of counsel, which isn't unsworn statements of counsel, which isn't evidence, to say that, to come up with the idea that the court thinks that Ms. Lavender is receiving more than $1,000 a month in Social Security credit under Mr. Bryson's Social Security benefit. There is
but that's an 11-year-old order, right? That was entered in June of 2013.
No, Your Honor. This was actually in the order on July 5th, 2023, when the trial court terminated the alimony.
Well, the substantive issue that Judge Thomas just asked about, the determination of the entitlement to an offset and the application of Alabama law, that was determined by the trial court in 2013. And clearly there were some off-record discussions that occurred with counsel, at least there appear to be from the briefing we have in this court. So we cannot know, and certainly the trial court is in a superior position. But let's get back to the order on appeal. Did your client move for rehearing?
No, Your Honor.
And was there a requirement to do so?
No, Your Honor, because the court lacked subject matter jurisdiction to terminate. And let me be clear, we are only here today on the termination of her benefits.
But let's go back. Again, if we treated this and we considered this as a motion to enforce, which facially it was for an accounting, and to the extent that the trial court might have gone beyond that, right, and added something into that, was your client required to seek rehearing on that point?
I think if the court, if we were dealing with just a sufficiency of the evidence findings or finding of fact issues, then yes, we would be. But because we're appealing the threshold issue, really, of the court lacked subject matter jurisdiction to go as far as it did, we did not need to file a motion for rehearing. Plus, we treated this as a non-final order, and motions for rehearing and motion for reconsideration are non-permissible motions on a non-final order. And so if we had filed that motion for rehearing or reconsideration, it wasn't heard within the 30 days that we had to file our notice of appeal, we would have lost our ability to appeal this particular non-final order.
But counsel, why wasn't the 2014 trial court's order holding that Alabama law applies and specifically addresses what that means appealable? Why wasn't that order appealable?
So that order was not appealable, Your Honor, because it did not meet any of the threshold requirements of a 9.130 appealable.
Was it essentially a declaratory judgment?
I don't. I guess it could have operated as as granting declaratory relief, Your Honor, because it declared the parties' rights or interest as to a dispute in their interest as to the right of the application of law, and determined that Alabama law applied. And let me also state that the parties' agreement, and Your Honor, I'm sorry, I noticed that just now that my clock's not working, so I'm not sure how much time I have left, but I just want to let the court know. I don't know where I am. So but, Your Honor, the parties' settlement agreement says that it will be, that Alabama law will govern any action brought on the agreement. And so under Frazier v. Frazier, we're not disputing that Alabama law applies to apply a credit. So we're not trying to attack that issue necessarily. What we're saying, though, is that looking at Frazier v. Frazier, Benz v. Maddox, which Frazier relied upon, Self v. Self, which came after, those cases don't terminate anything. In fact, Benz v. Maddox and Self v. Self clearly state we're not terminating, and those were child support issues, but we're not terminating the support obligation. If the benefits change that the children are receiving under the Social Security benefit, if those change or are reduced in some way, the obligor still has the obligation. The obligation survives, and the obligor still has the obligation to pay the support amount under the terms of the support obligation through other means. And so that's the distinction with the difference here, is that the alimony as of right now has been eliminated, and Ms. Lavender doesn't have the right to go back to the trial court and ask for any form of enforcement or to determine the credits and that sort of thing.
Thank you, counsel. You are into your rebuttal time.
Oh, okay. Sorry, Judge. Thank you.
Good morning. May it please the court. My name is Chris Ritchie of Galloway Law Firm. We're here representing Mr. Bryson. A couple of maybe quick points. I think you're all well aware of the factual background and the tortured history of the case. But one thing I wanted to note is the standard of review. My position on that, I think there are some issues in here that would probably be looked at de novo, but because the order on appeal denied a motion for contempt and a motion for an accounting, our position on that is that would be an abuse of discretion standard. That's the orders we're here about today. I think there was a question about kind of the 2014 hearing and whether there was actually a motion for rehearing or motion to reconsider that, and specifically what the court did on that. Ms. Lavender's argument essentially was that Alabama law does apply, but the Frazier case does not apply at all. There was a motion for rehearing in 2014, which they argued essentially that would constitute a modification. So that was about 10 years ago, and we're still kind of, I think, back to arguing about that issue. That was addressed back then, and so one of the issues we briefed was whether this is appealable at this time, because that decision was made that there was going to be a credit provided based on the Social Security payments. That decision was made back in 2014. And then going forward now, we've got these motions that deal with an accounting and a motion for contempt.
Well, and I think to be fair to the appellant, there never was an evidentiary hearing. Again, probably one of the 5 prior counsels' failure to bring it up for hearing of any evidence of what the Social Security offset should be. But clearly the order on appeal was in response to a motion for contempt and a motion for accounting. And to that extent, you don't disagree that the trial court had subject matter jurisdiction on that order, correct? That the trial court did. Let's start there.
I don't think I disagree that the trial court had jurisdiction to consider
Right.
those.
But the trial court did go on in its order to address an issue that was not pleaded in that motion that was on hearing to terminate the alimony obligation. And would you agree that the law in Florida is that is not something that can be done absent petition, and there has been no prior ruling that the alimony obligation itself was terminated? Isn't that correct?
I think I agree with that mostly, Judge. I would say that when the court decided in 2014 that Frazier does apply to this case, the court was essentially saying there's going to be a credit, there's going to be an offset at that point.
Fair enough. And I think that the question I'm asking is, would you, at this point, having considered the briefs, the record, and heard arguments by counsel and the questions from the bench today, would you concede error as to the trial court's legal determination in the order that the alimony obligation was terminated?
Judge, the reason I think that's hard for me to answer is it's clear that Florida law provides that the trial court could not modify the judgment or
terminate it, right?
That's
okay.
right.
And it's been your consistent argument, has it not, that the Social Security obligation under Alabama law is a set-off against the alimony obligation, correct?
That's right, Judge.
Right. So why wouldn't you concede today that that additional language in this motion on the contempt and accounting order was erroneous, and at least we should remand a strike? Would you not concede error on that point?
Well, I think there's 2 issues. One is whether it would need to go back for the court to have an evidentiary hearing on the question. In terms of the termination, I think from the perspective we've been looking at this, when you have the Social Security payment is being made, it's still being made. She's still getting the benefits. We don't have a situation where there's a change of circumstance, or the Florida court, the trial court did not, go back and void the Alabama decree. The payments are still being made.
I understand that perfectly, but your client has never moved to terminate alimony, correct?
I think that's true, Judge.
Right, and no party has sought to terminate or modify alimony.
Judge, I think this is in appellant's brief. Mr. Bryson did file an early pleading asking for a reduction in the alimony, and I think arguably that could be considered a modification, and maybe that wasn't proper, but he did do that.
So let's assume this. Let's assume we were to affirm on the contempt and accounting, remand with instructions to strike the surplusage in that order dealing with termination. That would leave the parties back with the pleadings, and it would allow your client, would it not, to seek the overpayments, right, that were made to the former wife?
I think so, Judge. If that were to happen, I think he would have the ability to do that.
So it's all fair game at that point?
I'd suppose so, Judge. I mean, I think what the court was struggling with here was that the Social Security payments were rising each year. And there is in the appendix, here we have the prior payment was $640. I think that was back 10 years ago.
Right.
And I don't know if the court, Judge Miller has been doing this, so I don't know if he did his own calculations, but he made a determination that would have exceeded $1,000.
And
this time.
on remand, the trial court could do many things. It could dismiss for failure to prosecute or waiver, lots of arguments that could be made, or it could simply have a hearing on what the amount of the offset is. But that's not really the question before us. The question before us is, is this order, affirmable? And I think as to the termination of alimony, to the extent that the former husband didn't move for it, and to the extent that the trial court had no jurisdiction to enter that order, my hope is that you would concede error, that wasn't a proper determination in the final order, or
Judge,
the
I
non-final
understand.
order.
And I don't think we necessarily, and I don't think that we briefed whether or not, if the panel decides that the court needs to go back and the trial court needs to have an evidentiary hearing and consider the exact amounts and do
But
that.
counsel, the specific question is, do you concede that the trial court's order with the statement that alimony was terminated as a matter of law erroneous?
Judge, I don't think we do, because if the credit, I think I'm trying to separate the question from whether there should have been an evidentiary hearing to take evidence on that issue. But in terms of the application of the credits, that was decided.
I think you're arguing concepts. We're in the business of words, and the order says it's terminated as a matter of law, perhaps inadvertent usage by the trial court, but surely, you can agree potentially that termination as a matter of law is an error. I understand
agree.
your concept argument.
Judge Thomas, I agree with that.
Okay.
Because I don't think the word termination should have been used. I think what he was saying at this point is, because of the amount of money Ms. Lavender was receiving in Social Security, that the alimony obligation was satisfied.
And I think that's a fair inference, but it's not what it says.
That's true.
And I think I think that's where you're hearing us asking you, at least as to the words used by the trial court, that's erroneous as a matter of law, because the trial court wouldn't have had jurisdiction to enter that type of order.
I agree with that, Judge.
Okay.
I think that wording, the word terminate, I agree with you.
Right.
With that as a given, should we remand to the trial court to strike that language and affirm, or should we reverse and send it back to the trial court?
Judge, I guess my position would be that whether there's a striking of it, I think I don't know how much that part is going to affect how things go forward, whether it's stricken or whether it's just sent back for further consideration. I do think that the language was improper because the trial court couldn't terminate it. I think if what the court was trying to get to is that he found that the alimony obligation has been satisfied. He didn't get rid of it, but he's saying, well, she's receiving this $1,000 a month. And that was the obligation under the Alabama judgment, and therefore it's basically being satisfied. I think the word terminate wasn't proper. And
Right.
if Your Honor, I guess to your question, I wouldn't think we'd have a problem with the court striking that part of it to the extent that it's using that language. But going back to the concepts, I mean, I think we're standing by our general position that Frazier does apply.
And that's an argument you can make to trial court. I don't think that the court is suggesting that remand for a hearing or proceedings or anything like that. The issue before us is whether this particular order should be affirmed, reversed, or if the trial or remanded to strike in part. And whatever the trial court does based on the record before him is something that he can determine based on the arguments presented.
Yes, Your Honor. And with that clarification about the language and the word terminate, I don't have an issue with that. I agree with that it probably was not worded correctly. And it's a little different, I think, than the theory that we.
On the other hand, though, if we reverse, what instructions should we give the trial court on remand, if any?
Judge, I guess one question would be if the court determines that the prior ruling of the court, essentially there was a motion for rehearing back in 2014, if that was appealable and there was no appeal at that time.
Would res judicata effect apply if it wasn't appealed?
I'm sorry, Judge?
Would res judicata apply if that order wasn't appealed?
Judge, I don't know if it's res judicata. I guess my question would be if you have an appellate issue at that time when the judge says we're applying Frazier, And we're going to start doing these credits and offsets. It's something that Ms. Lavender and her deposition and her prior counsel said, we don't believe Frazier applies at all. I think that maybe should have been appealed at that time. It wasn't. So we get here now, and I think your question is about res judicata. I don't know that it's res judicata, but I guess the question is whether that had to have been appealed back then. And now we're here on a motion for an accounting and a motion for contempt. And so the question, is, I guess, to me is whether or not
That
this
is
is.
exactly the issue. It's law of the case. It wasn't appealed. That argument's gone. It continues to keep coming up, as Judge Miller discussed. That ruling was made in 2014. There was no appeal. So we have an offset. I think that's the law of the case. We have an offset, and here we are now.
I think that's right, Judge. So I think the question on that then really is, right, where do we go from here? Our position is that Frazier does apply, that there should be credits provided. There was also, it hasn't been mentioned yet, but there was discussion in the briefs about a settlement that was entered into between the parties during some of these issues, and it might explain why there was such a passage of time. Maybe change of counsel, but there's a letter, this is in the amended appendix, page 71, a letter from prior counsel from Ms. Lavender acknowledging that they received, this is in June of 2014, that they received a check for settlement, but the letter says we do not intend to cash the check. So that's another wrinkle in this case. This was raised to the trial court. I think there might have been a previous judge on it at the time, but the parties went outside and reached an agreement. This is the argument. And then in the record, there's a letter stating that we have the check, but we don't agree with the deal. And so that was another wrinkle in all of these things that were happening at the same time as well. And I believe that might have been a resolution of everything. That's another wrinkle. I'll be happy to answer any further questions.
Thank you, counsel.
Thank you very much.
Your Honors, may I approach?
You may, counsel.
Thank you.
Counsel, before you begin, I have one quick question.
Yes, Your Honor.
Having heard the discussion with the court and opposing counsel, do you withdraw your motion for sanctions under Rule 9.410?
Your Honor, it's difficult for me to do that on behalf of my client because I think if they had withdrawn their arguments that the court had subject matter jurisdiction or had conceded that error in their answer brief, we wouldn't have had to go through the exercise of addressing those issues in a reply brief and possibly not even come to this court today because we could have resolved these issues.
Well, as you heard the dialogue, I mean, I think the arguments are a little bit more nuanced than that about subject matter jurisdiction. So
Yes.
again, it's your obligation as the officer of the court. Do you stand behind your statements that Appellate statements were sanctionable?
At the time, I believe they were, but yes, Your Honor, I will concede and withdraw that.
Thank you.
And Your Honor, I wanted to address the court's question regarding should the court just strike the language or should the court reverse the order in its entirety. And I think the court should reverse the order in its entirety because it still determined evidentiary issues without an evidentiary hearing. It relied on unsworn argument of counsel regarding the existence of a settlement agreement that does not exist anywhere in either appendix filed with this court. It does not exist in the record whatsoever. The parties' settlement agreement is clear that any modification must be in writing and signed by the parties or it must be by the court. And so, and then the other thing is that language, because the court was without subject matter jurisdiction to have that language in the order, it renders the order void under Menino v. Menino in Florida, under Hanna v. Hanna in Alabama. So whichever law is being applied on that issue, both jurisdictions are in accord that without subject matter
But
jurisdiction.
you're not
order
contesting
void.
the fact that the husband, former husband, is entitled to a credit or offset for the Social Security?
Not at all, Your Honor. And that's the crux of our argument, is that the obligation has to still exist for a credit to be able to be applied against it, because if it doesn't exist, there is no credit to apply against it. There's no offset.
And your client's aware, obviously, that opens her up to a potential overpayment counterclaim in this case.
It does, potentially, Your Honor. I would like to just address that point briefly. In our Appendix R, there's a report of a Social Security benefits being paid, and that particular report, and it's our understanding that this is the only thing in the record that talks about it, is it gets into the facts of how much Ms. Lavender is receiving under Mr. Bryson's credit versus how much she's receiving under her credit. And that gets, at that point in time, gets nowhere near the $1,000 per month. So, but that's why the trial court has to take evidence on these issues to determine exactly what that credit or offset should be under Frazier. Your Honors, if you have no further questions, I'm sorry, Judge, just if it's not clear, we would request that the court reverse the order on appeal, remand the case back to the trial court with instructions to consider the enforcement and accounting issues in light of enforcement proceedings, not in modification proceedings, as the trial court does not have jurisdiction to modify the alimony and life insurance benefits in this case. Thank you.
Thank you, counsels, for your respectful oral arguments this morning. This concludes our oral arguments for this morning, and we are adjourned.
All right.
Thank you. You want us to leave the cups or take them with us? We'll take care. Okay, thank you very much. Yes, sir. as